Let me tell you about a case that started with a simple question. Should workers be paid for the time they spend getting ready for work? This all began at IBP Inc., a company that produced fresh meat products. Working at a place like IBP wasn't your typical desk job. Employees had to wear protective gear before stepping onto the production floor, where they would spend their shifts cutting and processing meat. Now here's where things get interesting. IBP had a policy about when the workday officially started and ended for its production workers. They only paid their employees from the moment the first piece of meat was cut to the moment the last piece of meat was finished. But what about all the time that the workers spent on putting their protective gear on or walking from their locker rooms to the production floor? That time wasn't paid. One of the production workers, with the last name of Alverez, didn't think that was fair. He believed that the time spent donning or putting on and doffing or taking off protective gear, as well as time spent walking to and from the production floor, should be compensated. Now, Alverez wasn't just thinking about himself. He actually brought a class action lawsuit on behalf of all the production workers at IBP. The case made its way to the United States District Court for the Eastern District of Washington, and the court sided with Alverez. They found that under the Fair Labor Standards Act, the time spent donning, doffing, and walking should indeed be compensated. Now, IBP wasn't satisfied with that ruling and appealed the decision. The Court of Appeals agreed with the district court's judgment. As the stakes were high, the case didn't stop there. The United States Supreme Court decided to step in and review the case. This meant that the highest court in the country was going to weigh in on whether companies like IBP needed to pay their workers for every minute that they spent getting ready to do their jobs, not just the time that they were actually cutting the meat. The outcome would have far-reaching implications for workers and employers across the country. Ultimately, the Supreme Court unanimously held that putting on protective gear and walking to and from the changing areas are, quote, integral and indispensable to the job's principal activities, and therefore they must be paid. However, the court said that the waiting time in a queue for protective gear was 2 steps removed from principal activities and is not compensable under FLSA regulations. But the time spent waiting to put on the protective gear before leaving for the end of the workday should be paid. Compensable work hours begin at the time the employer asks the employees to arrive. If employees are forced to wait at the beginning of their shift because the employer does not yet have protective gear available, employees will be compensated for their waiting time.